In our studio, joining me on our legal help space is Mukul Agarwal, Associate, Nishid Desai Associates. Mukul, thank you so much for joining us on the show today. Let's get started with the first question. Joining us on the line is Jitendra Rustagi. Hi Jitendra, what's your question?
Yeah, hi. My question is regarding, actually I bought a flat 3 years back from Builder Exotica Developers. And in the layout, I can see that there are 2 bedrooms. But like a month ago, and actually visited my flat for home loan purpose. And he told me that in the layout, it is actually 2 bedroom, but in original it is 3. So I have a few queries. One is regarding what could be the possible implications of such a mismatch, and second would be like, is there any possibility that I can modify the original layout?
Okay.
Yeah.
All right. So the buyer pays for something, is shown something, and the built-up area is something different. So whose liability is this? Because the buyer's title gets affected. So, and ultimately he has to run around offices and get it cleared.
Yeah, so Jitendra, in this case, since seller is the builder, it's actually his liability if he's submitting a document which is not correct. The remedy to that is not that complicated. You can actually approach the registrar and submit a fresh deed, a rectification deed, which you both have to enter. You need to first of all file an application with the registrar stating that this is the correct map and this is the reason for the actual discrepancy that arose in the beginning. The application, once accepted by the registrar, can proceed, and as far as your question regarding liability, the seller has the liability in this case. Over and above, if an intention is proved against, if an intention is proved that for any kind of wrongful gain he did that, he might also suffer some kind of a criminal penalty in this case.
And what about the enhanced cost that he'll have to now bear the brunt of, the buyer?
There is no enhanced cost. It will just be going ahead as a new rectification deed.
The space gets increased, the buyer has to pay for it?
That should be the seller's responsibility in this case. As I mentioned, the seller had the initial onus that he provides the correct document in the first go.
Okay. Next question coming in from Malbika Patnaik. Hi Malbika, go ahead with your question.
Hello everyone, thanks for picking my query. I have invested in a project at Bhubaneswar in August 2012. The completion date was February 2014.
Okay.
But in the meantime, on April 2014, builder got arrested in a land fraud case, another land fraud case. So our project was in midway.
All right.
So, and the director, there is no director to whom we can rely on to carry out the project. Because there were 3 directors in the company. One got arrested, 2 others long left before. They were left before.
Okay.
So my question is, what is our legal option? Whether go for the consumer case or a civil case?
Okay. Malbika had also shared us details that HDFC had released about 60% of the loan amount to her. So don't you think there's also a liability of the lender in this case, because they usually go for these tags, bank approved project. Right. So what process should she take now?
Right. So in this case, as far as I see, the developer has a power of attorney to my understanding, which is generally a JDA model that we adopt, and the developer was entitled to develop the property, but ultimately what happened is he got arrested. So in this case, what best remedy I would say is you look after for a refund of your claim, for which you can go ahead and file a case in the consumer court, or else a more stricter measure would be you find a winding up application in the court. For that you should first approach, you should first take the step of giving a statutory notice of 21 days saying that so and so is your issue and you want the money to be refunded back. As far as the bank is concerned, there can be a claim for deficiency of duty, but that is very much subject to the fact that what were the terms or what were the internal processes that the bank was required to follow while releasing the money. So once we can see that, you can approach the consumer forum against the bank also, if at all there is a deficiency of service, which I said depends on the terms of the contracts also.
All right, so Malvika, your best option is to seek a refund and to file some case wherein the assets of the company will be attached. Okay, next question comes from Davinder. He wrote to us saying, I signed a notarized leave-in license agreement of 11 months. The licensee has now sublet part of the house against my agreement, and his relatives are, the licensee's relatives are staying in that part now. The licensee is also not paying any rent and is threatening force against the landlord. The licensee's relatives are to be treated as trespassers, he wants to know, and how should he evict the licensee?
Yeah, so this is quite a normal scenario. We keep on seeing these kind of cases a lot, and what you should keep in mind that eviction would specifically depend on whether or not the property is covered under some kind of rent control laws. If it's covered under rent control laws, then the tenant does have a right to first get a notice and then also rectify whatever problem is there. If he does that, then the landlord cannot effectively evict. However, in your case, irrespective if it's covered under rent control or not, what you should do is you should at least send him a notice, a written notice stating that you need the property to be vacated, and it will be advisable from a rent control and a non-rent control perspective also that you mention that why you want the property to be vacated. You can suppose mention that you need the property for your own personal use, your parents' use, or for your children's use. That gives a strong ground for eviction tomorrow. And then going forward, you can file a case for possession of the property in the court. Once you get a judgment in your favor, the execution process can begin, and that's generally done through the sheriff. And with respect to the criminal part, if at all, I understand in such situations it does happen that the person tries to intimidate and say that he'll cause some kind of a harm to the landlord. You can very well approach the nearest station officer to file a FIR. If the FIR is not registered over there, you can go to the Commissioner of Police. If not, you can file a criminal complaint, a complaint in the magistrate's court, and he can then take cognizance directly of your matter.
Mukul, will Davinder get a fair fight? Because what we know, the Rent Control Act presently is quite archaic. The government is even trying to tweak it. It's heavily skewed in favor of the tenant.
It is. So as I mentioned, in your notice, you mention that you need, there are certain specific grounds in which you can actually carve out that, okay, the tenant should actually evict. Say you need to pose some kind of a genuine ground and say that I actually need the property for my own self. I don't own any kind of property, and maybe my children are coming back from, or my parents do need the property for staying. I don't have any other place to stay, and hence I need it. You should be genuine in that. Show that you're genuine and be very strong on the paper. That would I say.
All right, Mukul Agarwal there, helping you out, giving you advice on how to deal with your legal property disputes. Mukul, thank you so much for joining us.
Thank you.